Tonight, when you walk into a courtroom, you expect someone in charge, a judge, a robe, a gavel, a single person with the authority to decide your fate. You have never questioned why that person exists. You have never had to. But here is what nobody tells you. For most of human history, that person did not exist. Courts ran without judges. Justice happened without them. And in many cases, it worked better than what you have today. That is not a provocation. That is the historical record. The idea that justice requires a single authoritative figure sitting above everyone else is not ancient wisdom. It is a relatively recent invention. And when you trace the origins of courts back far enough, you find something that looks almost nothing like what you walk into today. You find communities. You find neighbors. You find systems built entirely on collective memory, social pressure, and the terrifying power of public shame. So where did judges actually come from? And what does the world before them tell you about what justice really is? To answer that, you need to go back. Far back. Before Rome. Before Greece. Before the first written law code. You need to go back to the place where human conflict began and where humans first had to figure out what to do about it. Picture a settlement, sometime around 10,000 years ago. A small cluster of people, maybe 40 or 60, living close enough to share resources, close enough to argue over them too. Someone takes something that does not belong to them. Someone injures someone else. Someone breaks the unspoken rules that hold the group together. Now what? There is no courthouse. There is no judge. There is no law book. There is only the group. Anthropologist Christopher Boehm spent decades studying how pre-state societies handled internal conflict. His research, detailed in his landmark work Hierarchy in the Forest, found that hunter-gatherer and early agrarian communities across the world independently developed similar systems for managing wrongdoing. These were not chaotic systems. They were not primitive systems. They were precision instruments for social survival. The tool they used was not punishment, not first. The first tool was discussion. When a conflict arose, the community gathered. Everyone spoke. Not a selected few. Not a trained elite. Everyone. The person accused spoke. The person harmed spoke. Their relatives spoke. Neighbors spoke. The goal was not to establish guilt in a modern legal sense. The goal was to reach consensus about what had happened and what should happen next. Boehm calls this reverse dominance hierarchy. The group collectively acted to prevent any single individual from accumulating unchecked power over others, including the power to define justice unilaterally. This is the opposite of a judge. These early assemblies had no formal name, but their function was clear. They were courts without courtrooms. They were law without lawyers. And they operated on a principle that modern legal systems have spent centuries quietly dismantling. The idea that the people most affected by an outcome should be the ones who decide it. You might think this sounds messy. You might think it sounds slow. But consider what the alternative cost. The moment you hand the power of judgment to a single person, you create a vulnerability. You create a point of failure. One corrupt official, one biased ruler, one frightened or angry or bribed human being, and the entire system warps. Early communities knew this, not as philosophy, as survival. A group that allowed one person to control the definition of justice was a group that had handed someone an extraordinary weapon. Legal historian Harold Berman, in his monumental study Law and Revolution, traces the slow centralization of legal authority in medieval Europe and finds something striking. The communities that resisted judge-centered systems the longest, those that held on to collective arbitration models, tended to be more socially cohesive, less prone to cycles of vengeance, less likely to erupt in the kind of escalating blood feuds that plagued societies where justice was handed to a single chieftain or lord. The math made sense. When a community decides together, the community owns the outcome. When one person decides, everyone else is just a spectator. Now look at what ancient legal cultures actually built.
The thing. That is what the Norse called it, not the creature from science fiction.
The thing, an assembly, a gathering of free men and sometimes women who came together to settle disputes, make laws, and hold the powerful accountable. The Althing of Iceland, established in 930 CE, is often called the world's oldest surviving parliament. But it was not primarily a legislative body in the modern sense. It was a court without a permanent judge. Cases were heard, argued, and decided by the assembly itself, with a figure called the law speaker, whose only job was to recite the laws from memory, not to interpret them, not to rule on them, but simply to make sure everyone knew what they were working with. Justice was the community's responsibility, not a specialist's. Go further east. The village panchayat system across South Asia, documented by scholars including legal anthropologist Mark Galanter in his work Competing Equalities, operated on a nearly identical principle for thousands of years. 5 respected community members, not judges in any formal sense, would convene to hear disputes. Their authority came not from the state, not from a law school degree, not from a robe or a gavel, but from the trust the community placed in them. Their decisions held because the community agreed they should hold. The moment that trust collapsed, the system reformed around new figures. This is something your modern legal system almost never has to earn, and almost never risks losing. A judge's authority does not depend on whether the community believes in them. It depends on whether the state does. That is a profoundly different thing. But here is where it gets counterintuitive. You might assume that these communal systems were softer, more lenient, that without a professional judge to impose order, outcomes were inconsistent or toothless. The historical record suggests something more complicated and more unsettling. Communal justice, precisely because it relied on social bonds, could be far harsher than anything a judge would impose. When the community itself decided you were guilty, the punishment was not just legal, it was total. Ostracism, exile, the complete removal of your name from the social fabric. In many cultures, this was considered a fate worse than death. You were not imprisoned, you were unmade. You became a person without a people. The Romans had a term for this, capitis diminutio maxima, the maximum reduction of legal standing. A person subjected to this lost everything, their citizenship, their family ties, their legal personhood. They ceased to exist in the eyes of the law and in the eyes of everyone who lived inside it. That was the original sentence. Not 5 to 10 years, erasure. And communities could impose it without a single judge's signature. Tacitus, writing in the 1st century CE, described the Germanic tribes north of Rome in his ethnographic work Germania. He noted something that puzzled him. These people had no professional judges, no formal legal apparatus by Roman standards, and yet their communities maintained remarkable order. Disputes were settled in open assemblies. The accused faced not a magistrate but their neighbors. The social pressure of that audience, Tacitus observed, was more powerful than any legal sanction Rome could construct. Because you could appeal a Roman sentence, you could bribe a Roman official, You could not appeal the memory of your community. So what happened? How did the judge appear? The short answer is complexity. As communities grew, as trade expanded, as strangers began to interact with one another regularly, the assembly model started to creak. You cannot convene 60 neighbors to settle a dispute when 60 neighbors no longer know each other. You cannot rely on community memory when community is no longer the organizing unit of society. The state stepped in, and the state brought its own logic. Centralized authority, professional arbiters, codified law. The judge emerged not as an improvement on communal justice, but as a substitute for it. A necessary substitute, perhaps, but a substitute nonetheless. What was lost in that substitution is something legal scholars are still arguing about. What you lost was ownership. You lost the sense that justice belonged to the people it affected. You gained consistency. You gained scale. You gained something that looks, from the outside, like fairness. But you gave up something that those early assemblies had that your courtroom does not: the requirement that the community justify its decisions to itself.
A judge must justify their decision to the law,
To precedent. To a higher court, perhaps. But not to you. Not to the people in the room. Not to the community that will live with the outcome. That accountability was baked into every communal court that ever convened around a fire or in a village square. The assembly had to look at the person they were judging every day afterward. That changes how you judge. Legal theorist Roberto Mangabeira Unger has argued for decades that modern law is haunted by this absence. That the technical precision of professional legal systems produces outcomes that feel correct on paper and wrong in lived experience. That the gap between legal justice and felt justice exists precisely because the people experiencing the outcome were removed from the process of producing it. He is not alone in that argument. And you feel this. You feel it every time you read about a verdict that followed the law perfectly and still seemed wrong. Every time a technically guilty person walks on a procedural error. Every time a technically innocent person is destroyed by a system that found no crime in what destroyed them. The judge did their job. The law was followed. And something still went wrong. That wrongness has a history. It is the history of what was traded away when the assembly dissolved and the judge took the bench. Tonight, when you sit in that jury box, if you ever do, you will be the closest thing your civilization has to what those early assemblies were. Not the judge, not the lawyers, you, the untrained, unrobed, unremarkable citizen who has to look at another human being and decide something that will follow them forever. The system treats that moment as a remnant, a democratic gesture built into an otherwise professional machine. But it is not a remnant. It is the oldest part of the entire structure. It is the thing that was there before everything else, before the robes, before the gavels, before the courtrooms, before the law schools and the precedents and the appeals. Before any of that, there was just a group of people who had to decide together what was true and what should happen next. You are still that group. The building just got more complicated. Tonight, when you walk into a courtroom and see the judge sitting above everyone else, you are looking at a very recent answer to a very ancient problem. And the question those early assemblies were asking, the question they answered together, out loud, in public, with no one above them, is the same question every legal system in human history has tried to answer since. Not who has the authority to judge, but whether the judgment was just. They had to earn that answer every single time. No robe gave it to them.